The word ambush exploded from Prince Harry's legal team like a grenade tossed into an already volatile courtroom, and the shrapnel is still flying. Let me be brutally honest about what just unfolded in London. Harry's attorneys stood before the court and accused Associated Newspapers Limited of deliberately sandbagging the Duke, forcing him to take the witness stand an entire day earlier than scheduled. They called it a calculated attack. They called it unfair. They practically called it a war crime against their precious client. But here is the thing that should make every single one of you sit up straight in your chairs. A veteran UK criminal defense lawyer with decades of experience is now on record saying Harry's entire ambush claim is, and I quote, complete performative nonsense. Jonathan Goldberg, Casey is not some random legal commentator looking for his 15 minutes of fame. This man has tried over 100 murder cases. He has served as a part-time judge. He has seen every trick in the book, every theatrical display, every attempt by wealthy clients to manipulate the court of public opinion while pretending to care about the court of law. And when he looked at what happened in that courtroom, what he saw was not a prince caught off guard. What he saw was a performance. A rehearsed, carefully orchestrated performance designed to make Harry look like the victim, even as he wages an unprecedented legal war against the British media. The scene inside that London courtroom was nothing short of chaotic. Harry arrived looking rattled, his team loudly protesting the schedule change, reporters scribbling furiously as they sensed blood in the water. This was supposed to be Harry's moment of triumph, another chapter in his 6-year crusade to make the tabloids pay for every perceived slight, every intrusive photograph, every story that made his blood boil. Instead, it became the most combative, contentious, and revealing day of his entire legal journey. The combative exchanges, the judicial interventions, the moments of visible emotion, they all painted a picture that Harry's carefully curated public image cannot survive. Sources close to the proceedings described it as watching a man at war with himself. He wanted to be seen as the sympathetic victim, but he could not stop arguing. He wanted to appear composed and royal, but his hostility kept bleeding through. One courtroom observer put it bluntly, saying Harry seemed to forget he was supposed to be answering questions, not prosecuting his own case from the witness box. And folks, that distinction matters more than you might think, because in a British civil case, there is no jury to sway with emotional appeals. The judge decides everything, every fact, every interpretation, every penny of damages. The judge is the only audience that matters. But what Jonathan Goldberg revealed about how lawyers prepare their clients for testimony is about to change how you see every emotional moment Harry delivered. And trust me, you are not ready for this. This is not just another celebrity lawsuit. And it is not just another round of Harry versus the media. What we are witnessing is genuinely historic, and I mean that in the most literal sense possible. Prince Harry has now become only the second royal since 1891 to take the witness stand in a British court. Let that sink in for a moment. 133 years. That is how long the British royal family managed to avoid having one of their own subjected to cross-examination in open court. The last time it happened, Queen Victoria was still on the throne, and the future King Edward VII was dragged into a scandal over an illegal card game called Baccarat. The parallels between these two cases are almost eerie when you examine them closely. In 1891, Edward was subpoenaed after a member of his social circle accused another of cheating at cards during a house party the prince had attended. Edward desperately tried to avoid testifying. The palace deployed every weapon in its arsenal to keep him out of that witness box. But the legal system did not bend, and the future king was forced to answer questions under oath, while the entire nation watched in scandalized fascination. Sound familiar? The embarrassment was so profound that Queen Victoria reportedly refused to speak to her son for months afterward. The monarchy learned a lesson that day. Stay out of courtrooms at all costs. And yet here stands Harry, not dragged unwillingly into court, but charging toward it with both fists swinging. His legal crusader is David Sherborne, a barrister who has become something of a celebrity himself in these media cases. Sherborne has represented multiple high-profile clients against British tabloids, and he has developed a reputation for emotional, dramatic courtroom tactics that play well in the press, even when they do not always convince judges. He and Harry have been locked in this battle for 6 years now. Lawsuit after lawsuit, appeal after appeal, a seemingly endless war of attrition against publications Harry believes destroyed his life. But Jonathan Goldberg sees something troubling in this crusade. He points out that Harry appears to have developed what he calls a 24/7 litigation mindset, a state of perpetual legal warfare that has consumed his identity and his purpose. The expert suggests this is not really about specific articles anymore. It is about revenge, validation, and proving to himself and the world that he was right to burn every bridge that connected him to his old life. But here is the question that legal insiders are quietly asking. Was Harry actually caught off guard by that schedule change, or was every single moment in that courtroom, including the tears, carefully planned from the very beginning? Harry will have been rehearsed to the nth degree. Those are the exact words Jonathan Goldberg used, and they should fundamentally change how you interpret every second of Harry's testimony. This is not speculation. This is not media spin. This is a veteran criminal defense lawyer explaining exactly how the sausage gets made in high-stakes litigation. Clients do not just wander into courtrooms and wing it. They are drilled. They are prepared. They are coached on every conceivable question and trained to deliver responses that appear spontaneous but are anything but. The legal expert explained that preparation for a case of this magnitude typically takes months. Harry's legal team would have anticipated every line of attack, every uncomfortable question, every attempt by opposing counsel to rattle their client. They would have run mock cross-examinations. They would have practiced emotional moments. They would have discussed strategy for handling hostile questioning while appearing sympathetic. The notion that Harry was somehow ambushed, somehow unprepared, somehow caught off guard by having to testify a day earlier is, according to Goldberg, laughable on its face. Allow me to translate what was really happening in that courtroom. Both legal teams were engaged in sophisticated gamesmanship, each trying to gain psychological advantage while the world watched. Associated newspapers wanted Harry on the stand while he was still adjusting to the environment, before he had another night to rehearse his responses. Harry's team wanted the optics of appearing victimized, of being able to frame their client as the underdog fighting against powerful media bullies who do not play fair. Both sides knew exactly what they were doing. Neither side was actually surprised by anything. Sources familiar with high-stakes litigation describe this as standard operating procedure in cases involving wealthy clients and global media attention. One legal insider noted that the ambush narrative was almost certainly prepared in advance, a complaint ready to be deployed the moment opposing counsel did anything that could be characterized as aggressive. Another observed that claiming surprise is itself a tactical choice designed to lower expectations and make any stumbles appear more forgivable. The strategic reality is brutal but simple. Harry's legal team knew this cross-examination was coming. They knew the articles in question, the timeline of publication, the witnesses who would be called, and the arguments A&L planned to make. They prepared for all of it. The idea that a schedule shift of 24 hours somehow threw their entire strategy into chaos insults the intelligence of anyone paying attention. But here's what Harry's performance in the witness box revealed that even his well-paid lawyers could not hide, and it is something the judge absolutely noticed. The judge had to intervene repeatedly to remind Harry that he was there to answer questions, not to argue with opposing counsel. Let that statement hang in the air for a moment. A royal prince standing in one of the most prestigious courtrooms in London, being told by the judge to stop fighting and start answering. Courtroom observers described Harry's demeanor as defensive and hostile from the moment cross-examination began. He interrupted counsel. He challenged the premise of questions. He offered lengthy explanations when simple yes or no answers were required. In short, he acted like a man who believed he should be running the show rather than participating in it. Jonathan Goldberg was careful to note that judges redirecting witnesses is not unusual. It happens in trials all the time, particularly when someone feels passionately about the subject matter being discussed. But the frequency and intensity of these interventions with Harry suggested something more troubling. The legal expert observed that Harry seemed to view the courtroom as just another battlefield in his ongoing war, rather than a place where facts are supposed to be established through careful, disciplined testimony. The critical detail that many observers miss is that British civil cases do not have juries. There is no panel of 12 ordinary citizens waiting to be charmed or persuaded by emotional appeals. The judge alone evaluates the evidence, determines credibility, and issues the final ruling. This fundamentally changes the calculation for any witness. Theatrical displays that might sway jury members can actually backfire with experienced judges who have seen every manipulation technique in the book and resent having their time wasted. One legal analyst put it bluntly: Harry was playing to an audience that was not in the room. He seemed more concerned with how his testimony would play on the evening news than with how it was landing with the only person whose opinion actually matters. That is a dangerous strategy in any trial, but it is potentially catastrophic in a case where the judge has sole discretion over outcomes. The 24/7 litigation mindset that Goldberg identified was on full display. Harry approached cross-examination not as a witness trying to establish facts, but as a combatant trying to win arguments. Every question became an opportunity to score points rather than provide information. Every challenge to his memory or characterization became a personal attack that required immediate counterattack. The psychology on display was not that of someone seeking justice, but of someone seeking vindication. And then came the moment that hijacked every headline and dominated every discussion of this case. But the question everyone should be asking is whether that emotional breakdown was genuine grief or a calculated strategic move. Harry became visibly upset when speaking about Meghan during his testimony, and the press went absolutely wild with coverage of his emotional moment. Camera phones captured his face contorting with apparent distress. Reporters described tears forming in his eyes. It was powerful television, compelling drama, exactly the kind of humanizing moment that generates sympathetic coverage and makes critics look heartless for continuing to attack. There is just one rather significant problem with all of it. Meghan Markle has absolutely nothing to do with this case. Let me be crystal clear about the timeline here because it matters enormously. Every single one of the 14 articles Harry is suing over was published before he ever met Meghan Markle. That is not a minor detail. That is the entire foundation of the case. These articles appeared before 2016, before Meghan entered his life, before their relationship, before their wedding, before their children, before their exit from royal duties. So why exactly was Harry crying about his wife during testimony about events that predated her existence in his world by years? Jonathan Goldberg provided an answer that should make everyone reconsider what they witnessed. The legal expert explained that lawyers routinely advise their clients about emotional displays. The standard guidance, according to Goldberg, is this: if you feel like crying, do not hold back. Let it loose. Judges and juries respond to authentic emotion, or at least to what appears to be authentic emotion. Tears create sympathy. Distress suggests genuine harm. Emotional vulnerability makes it harder for opposing counsel to continue pressing without looking cruel. The timing of Harry's breakdown is telling. It came during some of the most challenging questioning of the day, precisely when sympathy would be most valuable and precisely when Meghan's name could redirect attention from uncomfortable facts about articles that had nothing to do with her. Coincidence? Perhaps, but legal veterans do not believe in courtroom coincidences. Interestingly, Elizabeth Hurley testified the very next day using the same barrister, David Sherborne, and she also broke down emotionally during her testimony. Two witnesses, same legal team, same emotional displays within 24 hours of each other. The pattern is difficult to ignore for anyone familiar with courtroom preparation strategies. But here is what should really concern Harry. Jonathan Goldberg emphasized that the judge presiding over this case is described as hard-bitten, a term that means experienced, skeptical, and virtually immune to theatrical manipulation. Judges who have spent decades on the bench develop finely tuned instincts for distinguishing genuine emotion from calculated performance. What they watch for is far more revealing than tears. Associated Newspapers Limited has a technical legal defense waiting in the wings that could destroy Harry's entire case regardless of whether the underlying facts support his claims. This is the 6-year statute of limitations rule in British privacy cases, and it functions like a ticking time bomb underneath the entire proceeding. If A&L can demonstrate that Harry knew or should have known about his potential legal claims more than 6 years before filing suit, the case collapses. Not because Harry was wrong about the articles, not because A&L behaved ethically, simply because he waited too long to act. The legal mechanics here are genuinely devastating for plaintiffs who have sat on their claims. British law requires that privacy complaints be brought within 6 years of the claimant becoming aware they have grounds for a case. This is not when the harm occurred, but when the knowledge of legal recourse crystallized. The distinction matters enormously because it turns on what Harry knew and when he knew it, rather than simply when the articles were published. Evidence has emerged suggesting that some celebrity claimants may have, shall we say, adjusted their timelines to fit within the limitations period. A young lawyer's contemporaneous notes from meetings held years before the suits were filed have surfaced, creating serious questions about when various plaintiffs actually became aware of their potential claims. If those notes contradict testimony about timing, the implications for credibility extend far beyond the statute of limitations question. Jonathan Goldberg was blunt about what this means for the case. He suggested that some witnesses may have been less than fully truthful about their knowledge timelines, and he predicted that A&L's lawyers will pursue this angle aggressively. The strategy is straightforward. Attack the credibility of claimants on the limitations issue, demonstrate that they knew about potential claims years earlier than they admitted, and argue that the entire case should be dismissed on technical grounds before the merits are even reached. Sources close to A&L's legal team describe confidence about this defense. One insider noted that the documentary evidence from those early meetings is extremely problematic for several claimants, though they declined to specify which ones. Another suggested that internal communications will show a coordinated effort to time the filing of suits for maximum public relations impact rather than legitimate legal necessity. But the statute of limitations defense is not the only weapon in A&L's arsenal. The journalists themselves are preparing to do something that could blow the entire case wide open in ways Harry never anticipated. Will journalists be forced to reveal their sources, or will they face contempt of court charges and potential imprisonment for protecting confidential informants? This question looms over the entire proceeding like a storm cloud, and the answer could fundamentally reshape how we understand the relationships between media outlets and their royal sources. English law on journalistic source protection is complicated, nuanced, and often depends on the specific circumstances of each case. But one thing is clear: this is not America, and source protection here has significant limitations. Jonathan Goldberg explained the legal framework in detail. Courts can compel journalists to reveal sources in civil cases when the information is necessary to dispose of the case fairly, and when the public interest in disclosure outweighs the public interest in protecting source confidentiality. The balancing test is subjective, and different judges reach different conclusions. But in a case of this magnitude, with a royal plaintiff and global media attention, the pressure to get to the truth could tip the scales toward disclosure. Here is where it gets particularly interesting. Some sources may actually want to come forward now. Years have passed since these articles were published. Relationships have changed. Loyalties have shifted. People who once leaked information about Harry may feel differently about their obligations in 2025 than they did in 2015. As Goldberg colorfully put it, some sources may be ready to say, "Go to hell, Harry," and tell the court exactly what they shared and why. Harry himself has created a significant problem with his own claims about sources. He has repeatedly insisted that he had no friends who would leak information about him to the press, that he surrounded himself only with loyal confidants who would never betray his trust. But this claim is directly contradicted by his own Netflix documentary, in which he explicitly blamed the palace, meaning his own family and their staff, for feeding stories to journalists. You cannot claim you had no leaky friends while simultaneously producing content that identifies your family institution as the source of leaks. The contradiction is simply too obvious to ignore. If sources do come forward, or if they are compelled to testify, the revelations could be extraordinarily embarrassing. Who leaked what, when, and why are questions with answers that might not flatter anyone involved. The palace might be exposed as more coordinated in its media management than publicly acknowledged. Friends might be revealed as less loyal than Harry believed. The entire narrative of innocent prince victimized by predatory press might crumble under the weight of evidence showing a much more complicated reality. Meanwhile, something genuinely strange happened during the trial. Harry was spotted somewhere he had absolutely no business being, and the timing raises questions that deserve answers. After Elizabeth Hurley completed her emotional testimony, Harry was observed, and I quote, "kicking around Parliament." Let that image settle in your mind for a moment. The Duke of Sussex, in the middle of the most important trial of his life, wandering the halls of the British legislative seat rather than conferring with his legal team or preparing for additional testimony. What exactly was he doing there? The answer connects to another obsession that has consumed Harry for years and reveals a pattern of behavior that legal experts find genuinely troubling. Harry has been waging a separate legal battle over his security arrangements through a challenge to RAVEC, the body that determines which members of the royal family receive taxpayer-funded protection. He already lost this fight decisively in court. The judge found that the RAVEC decision to reduce his security level was entirely proper and that Harry had no legal grounds to challenge it. But losing in court has not stopped Harry from continuing to pursue the matter through every available channel, and Parliament apparently represents one of those channels. The security obsession has led Harry to some dark places. Reports indicate that he berated his own father, King Charles, for refusing to intervene in the RAVEC decision and restore Harry's security privileges. Remember, this confrontation occurred while Charles was undergoing treatment for cancer. Harry demanded that his cancer-stricken father pull strings to get him special protection, and when Charles declined, Harry apparently responded with fury rather than understanding. Harry has pointed to a specific stalker incident to justify his demand for RAVEC to reevaluate its decision. Someone allegedly approached or followed him in a way that made him feel unsafe, and he has used this event to argue that the original security assessment was flawed. But critics note that wealthy private citizens deal with security concerns all the time without demanding taxpayer-funded protection details. If Harry feels unsafe, he has the resources to hire any private security firm in the world. The insistence on government-provided protection suggests this is really about status and recognition, rather than physical safety. Jonathan Goldberg offered a particularly cutting observation about the security crusade. He suggested that Harry's demand for restored security privileges exposes his fundamental problem with understanding what privilege actually means. Harry has never had to do a day's work in his life. Those are the exact words Jonathan Goldberg used, and they cut straight to the heart of the contradiction that defines Harry's public existence. Here is a man who lectures the world about empathy, about service, about the struggles of ordinary people, while simultaneously suing media outlets for reporting accurate information and demanding that taxpayers fund his personal protection. The disconnect between his messaging and his actions has become impossible to ignore. The hypocrisy runs deep. Harry wrote a memoir called Spare, in which he exposed intimate family secrets, detailed private conversations, and revealed personal struggles that his relatives never consented to share publicly. He reportedly received approximately £20 million for this book. £20 million for violating the privacy of his own family. And yet he stands in court demanding damages because newspapers reported information about him that he considers private. Allow me to translate. Privacy for Harry is absolute. Privacy for everyone else is negotiable when there is money to be made. The drug admissions in Spare deserve special attention here. Harry openly admitted to using cocaine, marijuana and psychedelic mushrooms. He described drug use in vivid detail, apparently believing that honesty would be interpreted as bravery rather than foolishness. But here is the thing. Ordinary people who admit to drug use on visa applications are routinely denied entry to the United States. Harry not only gained entry, but apparently faced no consequences whatsoever for his admissions. The rules that apply to everyone else simply do not apply to him, yet he has the audacity to position himself as a champion of the marginalized. Jonathan Goldberg drew a comparison that should haunt both Harry and Meghan. He likened them to Edward VIII and Wallis Simpson, the royals who abdicated and spent decades in bitter exile, increasingly irrelevant and consumed by grievances. The parallel is obvious: a prince who chose love over duty, who left his country, who spends his days nursing resentments and fighting battles that no one else cares about. But Goldberg identified one crucial difference. Edward and Wallis at least had the dignity to fade quietly into obscurity. Harry and Meghan refused to go quietly anywhere. The legal expert's prediction about the case outcome might surprise some viewers. Goldberg believes Harry will probably win and receive some damages. The articles in question were intrusive. Some information was likely obtained improperly, and courts generally sympathize with plaintiffs who can demonstrate genuine harm. But Goldberg emphasized that victory in court is not the same as victory in life. The real cost of this crusade is measured in relationships destroyed, bridges burned, and a family fractured beyond repair. Two incredibly privileged people spending their time on this, Goldberg observed. There is something a bit sick about it, is there not?